All right, good evening, everybody. My name is Adam Hopler. I am an attorney here in Durham, North Carolina. You are watching a webinar this evening on how children are placed from a legal perspective. I have my alliterative title up tonight, but apparently that wasn't good for marketing, so I get to use it here, though. I also have with me on the phone for a moment Deborah Cousins from the Department of Social Services here in Durham. Deborah, how are you doing?
I am well, Mr. Hopler, and I just wanted to say I have no authority on this topic. I know Mr. Hopler because he was one of our great foster parents, someone that's trained and someone that reached back to the agency and said, how can I support you? What can I bring back to help our families? So this is a topic that was near and dear to his heart.
Absolutely, yeah. And Deborah, I really appreciate allowing me to talk with our attendees tonight. I'm just looking forward to kind of talking about the topic and fielding some questions. So over in the side, everybody has access to a comment box section where you can put in questions or comments about what you hear tonight. And I will do my best to follow up on those. We do have several folk from the Department of Social Services that are already online with us. So it may be possible that we field some information as we go. And so if we get to that, I do have the ability to bring some people live, but we'll kind of see how that plays out. It may not be necessary, but just a possible option. So with that, what I guess we'll do here for a minute, and I think it would probably be good just to introduce myself a little bit further. Like Deborah said, I am a former foster parent from Durham County. My wife and I were involved in foster care for about 4 or 5 years, I want to say, and then ultimately our family size wound up precluding us from being able to continue operating as foster parents. And so we definitely have a big heart for that and want to be there to support those who are going through it and thinking about it and exiting in all those stages. But professionally, I'm an attorney. I do estate planning and administration. So that means that I'm helping folk with wills and trust, or when a family member passes away. That's often where I will work and advise and consult and sometimes represent people in carrying out those particular actions. And so that's my, I guess, authority on the subject as an attorney. And so I'm going to try and tonight give a little bit of a spin on what might be my normal discussion with folk about estate administration and estate planning, particularly, with a focus on the idea of adoptive and foster context. So I think it's helpful to start by discussing the different context in which you may have people, or more particularly children, minors, in your home at any given time. And so I put up, kind of the I guess the standard instances in which you would see this. So obviously, children that are biologically born to you, those are the ones that are, we all kind of like, yep, that's ownership, take that, that's mine. I have to kind of plan and ponder, and what do I do with that? But it is also possible that you have kids that are in your home that are from someone else's marriage or previous relationship. And now that you've moved in and conjoined together, that you have what are referred to as stepchildren. So your spouse has children, again, that were from outside your current marriage. That's more and more commonplace, and it's not unusual. And so that is not a biological connection to you, but it is a biological connection to somebody else in your house. And then we have adopted children and foster children. And adopted children, we're going to talk about this throughout the night, is a very firm legal decree that a child that was not born to you is now going to, for all intent and purpose, be treated as if that was actually the case, that the child was born to you. And so that's a very clear legal distinction that we make when a child is adopted. If you're in foster care, you probably have heard this before and maybe even experienced it, where in fact a brand new birth certificate is generated for that particular child, and now your name, for father or mother, is placed in that document to say this child is yours. So that's a very firm, rooted establishment, and has a whole lot of consequences that we're going to discuss. Foster children, as probably a lot of us know who are in this, but maybe some of you are new to it. Foster children are children who are placed into your home while they are legally in the custody of one of the various departments of social services here in North Carolina. So there's 100 counties, 100 different departments of social services, and each one of them has authority given to them by the state in very extreme circumstances to remove a child from a home and to take them into custody, or if the child did not have a home to begin with, if that's the circumstance, and to then find a new placement for that child. And so in that context, if you are an adult, whether married or not, but you have gone through the MAP training and been qualified and certified to serve as a foster parent, you can have that child placed with you. Now, at that moment, when the child comes into your home, this is not the same as adoption at all. The child is not legally considered like yours to any extent. The child is very much legally in the custody of the Department of Social Services. So for our discussions then, when we talk about things like inheritance and where does it go, we have to consider very carefully children that are in your home. Which one of these categories do they fall in? Now, as I said before, adopted children, we're going to treat them exactly like we would biological. So we really don't make any legal distinction. And our law goes quite a number of places to make it very clear that doesn't matter if you're adopted, you get treated the same as if you were biologically birthed. And in some respects, it should be kind of hard to discern that a child was not biological if they've been adopted. Again, like I said, their birth certificate will say that they were born to them, even though factually that didn't actually happen. It's a legal truth that we bring about because of a decree that's occurred. So for inheritance purposes, if you adopt a child, that now means that child is going to inherit from you in the same way that any other child would. But what does that mean? You may not know like how that works. And so our laws actually have a line of what's called intestate succession. So if you pass away and you have not written a will, essentially our laws already have a will in place for you. And it will kind of dictate where your things flow down to. Obviously, if you're married, that's going to have a radical shift on how the law breaks it down. So spouses are going to inherit something in most, if not all, of what you have. Having children changes that calculus. So if you have a spouse and children, your spouse and your children are going to share. If you don't have children and you have living parents, your spouse and your parents will share. That's a little scary. I'll be thinking about that one the next time you're pondering whether you should do a will or not. But if you do have a spouse and you have children, then we're going to break it down by a percentage depending on how many children that you have. The threshold is whether it's 2 or more. And so a spouse could wind up getting a third or a half. So biological children now just add to that number. So if you had 1 and you adopt, you now have 2. Okay, you're going to have a certain half or 2/3 that get split between those 2 children, or if you have 3 and so on and so forth, they're going to take and split the same pot depending on the number of kids that you have. Stepchildren, it's important to note, are not considered a part of your intestate succession. So that is to say that if I pass and my wife and I had a child in our home that was the biological or even adopted child of only my spouse, that child is not included for the purpose of my inheritance automatically, that is. So from a legal perspective, it would look like I had no kids, even though there is a child in my home. Everything would go to my wife, unless, again, I had living parents, and then it would be split. So that's an important thing to note if you are in a blended family, is to ask yourself whether you have made arrangements or plans to at least clearly discuss how you anticipate the breakdown between your household contents in the instance that one of you passes. And so you want to be deliberate about that conversation. And I suppose it's also worth distinguishing, I didn't put this up there, but there is a category of what we oftentimes conceive as like half children. And that's a little bit of an odd statement, but like if I have a child and then for whatever reason remarry and then have another child with someone else, I may have multiple children with different mothers. All of those children are connected to each other through me. And so in that instance, because we only look at the individual, there isn't a distinction between half children. They are treated as, if they are all mine, as mine. And thus it goes through, and it doesn't matter who the other spouse was. And so even though we might in our minds make distinctions about having a half sibling, for instance, for the purpose of inheritance, it doesn't really change anything, again, because the common thread, the spouse that is the same, is the only person that we're looking at when we're determining who that person's heirs are. These things are going to be important. And so when you get to foster children, this is where it can sometimes bog down a little bit of like, well, what does that mean for that particular child if I should pass away while they're in my home? And so the quick answer to that is that legally, that child does not have any kind of inheritance right, and there's no inheritance obligation to the child, because they are still, until their rights are terminated, or if they happen to go home, if that winds up being the outcome, they're still connected to their biological parents up until the moment of any kind of, again, adoption decree. But it's also very possible, again, given the primary desire for reunification, that the child does go back home to their parents. And so we're not going to change a legal reality about inheritance until we've gone through every last possible measure to determine if that's what's going to happen. And so again, adoption is like the very last thing that occurs in a long road when dealing with a child who's been put into care. So as we've discussed, things that change the default, adoption is definitely one of those things. But short of adoption, you kind of have to have in your mind that we don't have any change in inheritance. And so if you're kind of planning ahead about what you're doing with your things and your stuff, or who's going to take on what, you need to be aware of that reality. We're going to talk about guardianship in a minute. Guardianship does not change inheritance. And so if you are a person that has been granted guardianship over a child, you should be aware that does not, again, change intestate succession. It does not create any kind of an obligation for inheritance. It is a placement, a custodial issue, but it is not a legal changing of that biological connection. So adoption will make a change. Obviously, doing a will or a trust is going to change things. Just because the state legislature decided that that's the way things will fall doesn't mean that you need to agree with that. And in fact, most people do not. And so it's very rare that I will sit down with somebody and discuss where things go and how they are handled. And they are like, yep, the state legislator, those folks, they got it right for me. It happens, I suppose, but not more often not. So if you draft a will, you can change it. If you place things into a trust, which is kind of like a little business, but it's just solely for your benefit and for the benefit of your heirs, that will change things because the terms of that document will control. It's also important to note that you may have lots of other kinds of financial tools at your disposal. For instance, life insurance policies, retirement accounts, 401k, 403b, general IRAs, Roth. All of those financial tools will have a what's called a designated beneficiary on them. And so if you write into your life insurance policy that your stuff goes to one child, but you've got three, you need to be aware that that's going to control. And so even if you wrote a will that said, for instance, you could do this, that you wanted to include a current child in your home, a foster child, or maybe just another child that like a relative or something to that effect, and you said, I want them to inherit from me or inherit something from me, that's fine. But you just have to be in mind that if you were thinking that what they were going to get is going to come from a life insurance policy, the will's not going to control that. And so you have to be very specific about the designations. Sometimes what people will do to kind of help unify things is either direct that their stuff goes into a will or your estate, or a trust that you create, and then that document will control because the life insurance has been routed in that direction. And then same thing with, again, retirement accounts, general bank accounts. If you have a joint account with a spouse or maybe one particular child, that's going to control before what your will says kicks in. So that can be a little bit confusing at times. And so it's just important to know that all of those things are considerations that you have to take into play when you're asking yourself like where stuff goes, or you're planning yourself where do you want things to go, because how you accomplish that very much depends on what it is that you're grappling with. Real property has its own rules, and with the deed, again, if a deed says that it's two people with ownership on it, that's going to have an effect on where it goes from there. Whether it's 50-50, and so if you pass, you take your 50% and it's controlled by your will, or if it's 50-50 with a right of survivorship, that would change the calculus also, because now instead of it dropping to your heir, it would just merge with the other. Now you have this unified whole. And so all of these factors go in, but it's important to note that these are things that change that default. I'll come back to the question. Sorry, I got distracted. So on guardianship, there are a couple contexts in which the idea of a guardian comes up. And so I think it's important to note that first, you have the ability for the specific circumstance in which both, and I'll use the term, I guess, biological parents are deceased and leave behind a minor child. And so for our purposes, when I say biological, I'm going to include adoptive in there. So if you have adopted a child or given birth to a child, and you are the parent for that child, and both parents pass before the age of 18, you can state with clarity and specificity in your will who it is that you want to take over, be the guardian, and make decisions on a day-to-day basis for your child. And that's a really big deal. And I think anybody who is in foster care begins to become aware of the reality of why that's such a big deal. Because, like we said earlier, if you have a child that does not have a home, and it is not clear where that child should go, it's not always the case, but it can be the case that the Department of Social Services is the one that steps in and trying to figure out what do we do in this particular situation. And again, as many of us might know, but if we're stating, the Department of Social Services has a preference for what we refer to as kinship placement. And so if there are family members that are able to take custody of the child, that's going to be the preference. But as some of us might realize, depending on your circumstances, that may not necessarily be clear as to who the most appropriate person is, or the most ideal person, or the person that's in the best interest of your child might be right off the get-go. And so if you have multiple family members that are all, let's say, good calls, there can be a little bit of a question at that point about, well who takes priority? And so for the purpose of our law, in terms of who takes priority for placement of guardian over a minor, we do not have a distinction of siblings of the decedent over children of the decedent, or aunts and uncles over cousins, or anything to that effect. And so there really is no ranking or prioritization as to family members who may, again, have perfectly good family situations and be perfectly capable of taking on the care of a child. And so we still have to figure out, well, what do we do? This is where the court will get involved in the determination of who an appropriate guardian should be. The irony that can occur, unfortunately, when there's ambiguity about that is, depending on the family situation, there may be a bit of a tense feeling or between them as to, well, I think I'm the best scenario for that particular child. And these folk over here think they are the best scenario for that particular child. So they now have to go to a court proceeding and explain to a court why option one, option two, and they're going to advocate each for their own interest, why they're the best fit. And that can take essentially two directions of argument, right? You could spend a lot of time focused on, this is what's really good about my situation. And that would be great and fine. But unfortunately, some folk will then take the direction of saying, and this is why this other option is not as good. And that can quickly devolve, as you can imagine, into some contentious fighting. So it's really not ideal, generally speaking, for it to be a bit of a free-for-all in that instance, where you just don't know who it is that is going to have a ranking priority, because it's going to lead oftentimes to all the people who should be working together in this instance to support a child who's experienced a pretty major loss, apparently, or a set of children. And instead of working together, they find themselves in a position where they're like, well, if I want to be the one to do what's right or what's best, I need to advocate for that. And it can cause distinction and strife between them. So that's something to be careful, certainly if you are ever a family member in that situation, to be mindful of that. But the system itself, unfortunately, does kind of lend itself in that direction. So what can you do? Well, in its simplest form, you pull together a will and you say, well, if that ever happened, myself and the other biological parent of the child, if the both of us are gone, right, then this is my preference. And you give a list, lay it out. Now, what's important to note when you make that kind of a list is that the list is a series of recommendations. It's not a demand or requirement. It's merely you giving your priority. So if your number one candidate at the time that you pass away is no longer viable for whatever reason or not willing, then they don't serve. And the court would then move to your number two and see if that's going to work. And if it doesn't, then they just keep moving on until they find somebody who is at the top, as far as to the top of your list that they can get, who again is able and willing to take on the care and management of your remaining child or children. And by doing that, you give clarity. Our law gives that the highest priority your particular appointment that you lay out in your will as to what happens to children again when both are gone. So it's hard to overemphasize the importance of taking that particular step. Now, I think just to kind of put into a little bit of context, this is a very specific kind of guardianship. And so you may hear the word guardianship come up in a lot of different contexts. And so you may hear about like a guardian ad litem. In fact, you probably hear about that all the time if you're in foster care, where you have a guardian ad litem that comes out to your home, and they will check in and advocate on behalf of a child that you currently have with you through foster placement. And they go to court and they report information about what they hear, and they are essentially a representative of the child in that court proceeding. That is very different from the kind of guardianship that I just discussed a minute ago, because that individual is not making actual day-to-day decisions or actually managing care or anything to that effect. They are looking into the circumstances and kind of acting as the eyes and the ears of the court. In fact, in a guardianship proceeding, we would have a guardian ad litem who would be appointed for a temporary basis, again, to represent the interest of the child, and trying to determine who would become the actual guardian for that particular minor child, if that were the situation that we're dealing with. So if you hear that terminology, notice that's very different from the kind of big guardian that we've discussed. And it's also important to note that there are other forms of guardianship that get used in district court, where in family custody issues where that'll pop up, and that's not going to be the same again as what we're discussing, which is that unique scenario where the biological parents have actually passed away. And so this guardianship is actually controlled by the clerk of superior court. If you don't know who that is, it's one of those positions that you check a box on when you go to your elections, and you may not have any idea what that function is within the city, but it is actually a really important position. And so I encourage you to take a look at that, especially as we kind of come up to that particular season, because there are plenty of folk who are doing a great job at that position, and you want to leave them where they are, or maybe you have reason to think otherwise. But the clerk of superior court is an elected position, and they serve in a judicial function in a lot of ways. And so even though it sounds like it's a purely administrative position, and there is a lot of administration that goes as a part of that particular position, that person actually has the ability to make judicial decisions like the selection of a guardian. And so you're going to start there in terms of figuring out what we do with, again, a minor child that needs to be placed in a particular situation. So to kind of put that in further context, when we have a situation in foster care where a child's parental or their child's parents, their parental rights have been terminated, that is tantamount to the same situation that I discussed before, where you have two parents that are now deceased. And so again, we need to fill the void. We got to find a placement. And so we will do a guardianship petition in that particular situation, and we'll want to appoint somebody. And so if you are in a situation where your social worker is discussing with you, what the ramifications or differences are, one of them is the inheritance issue in terms of like that connection to the family, because adoption is making a child, again, like as if they had been born to you. Guardianship is not creating that same kind of legal connection. And the obligation that you have as a guardian dissipates when the child is no longer a minor, when they reach the age of 18. So there's no ongoing, connection, if you will. So conceptually, if you're trying to ponder, what role it is that you want to take, those are some pretty significant considerations to think about, because there are plenty of foster parents who see their role within this story as being a temporary placement for a child or children. And so if that's kind of your thought process, then guardianship may make a lot of sense, because it means that you can help do what you want it to do, which is to get the child to a place where they're now moving forward, but not necessarily to continue past that, because you want to refocus on more children that are coming into your home. Whereas adoption, again, really does carry on that sense of like, this is permanent, it's ongoing, it's never ceasing. And so the child grows to the age of 20 and 30. And the idea would be that the same sort of familial connection that you would have would just continue in that direction. I mean, that's the thought process in theory. I know in practice, it may not work that way. In fact, you may have a situation where you've taken on guardianship, but you've really thought about it as if the child is now legally yours, even though that's not legally the case. And so in that case, if you're thinking, I didn't realize that was not the case, I have a child that's maybe 20 or 30, and I never adopted them. Well, this is where, again, some of the things that we discussed before come into play. Writing a will and making it clear that, okay, even though legally this may not be the case, that the child is inheriting from me, I want to set that up. I want to have it that way, because that's how I've always viewed it myself, and I wouldn't want there to be any kind of misgiving, because this is the way we've associated with each other. It's not uncommon for me to have consultations with folk that apparently that understanding wasn't in place. And so when somebody passes away, this person has been raised by their aunt or their uncle, but functionally treated like a child, a biological child. But it becomes apparent that from a legal standpoint, that wasn't the case. And so they are not included in the inheritance and in the process of resolving that person's estate. And it's an inadvertent slight in all likelihood. Like, it's not intended to mean anything. It's just that there wasn't an understanding about how that legal process works. So it's yet another reason to take a moment and really consider the uniqueness of your particular situation and ask, well, what have I done to make sure that the way I think this is supposed to happen is actually going to happen? And so, this is kind of what I was hitting on there, that when all of us are going to pass away at some point, and the legislature assumes that when you pass away that you will be very old. And that's one of the reasons that it's written the way that it is, why spouses and children are included at the same time. And so many times spouses between each other, they want to go ahead and say, well, I just want everything to go from one to my spouse. And then from there, we'll do kind of like sweetheart wills, where both of them say, all right, after both of us pass, that's when our kids begin to take things on. And you kind of want it that way in case it happens when your children are minors. But many people think that way also when they're older as well. You know, they want their spouse to be cared for first before children begin getting their share, so to speak. So taking the time to think through a will and ask yourself about that. You can, a comment is made in here about, tying up assets. Oftentimes this is where a trust may come into play. And so if you are thinking that through life insurance policies, real estate, liquidation of everything that you have, that you might have a fair sum, then in that instance, you may want to dole it out in slower doses and then just giving one big lump sum. And so that's where a trust would come into play. And so, I oftentimes will talk with parents about a trust, because you just don't want to give things to a minor, period. That's probably not going to work to begin with, but it's also a terrible idea. And so we will create a kind of trust situation so that somebody else will hold the funds for a period of time until the child reaches an appropriate age. But what an appropriate age is a question for a lot of folks. So hobbits, for instance, consider the age of responsibility to be 33 years old. Maybe that's where you sit too. You think that you're not really responsible until you're 33. A lot of folks that I talk to, we like round numbers for whatever reason, 25, 30, something to that effect. And so you can kind of think back to, maybe you are that age right now, in which case I'm sure you're a very responsible person. But I know when I was like, 20, 21, I made decisions that I thought were really responsible that I now look back at and kind of go, what was I thinking? And so you may say, I think I'd like to give my child a little more bandwidth than just 18. Again, I don't think I need to drop, all of the life insurance policy on them at once. And so there are ways, again, to kind of slow that out. Now, kind of a counselor moment for a minute. As an attorney, I'm going to draft documentation so that legally the things that you want to happen. But even with that being the case, because it's all done legally and through these fancy documents that I draft, that doesn't necessarily mean that everybody understands or follows the actual intent of what's being written. So historically, I feel like attorneys have had a vantage point of overthinking confidentiality. Certainly, anytime I'm meeting with somebody, I have confidentiality between attorney and client. But that doesn't mean that the client has that same level of confidentiality with everybody else. You are welcome to tell anybody whatever you want to tell them. You're also welcome to tell them nothing. Like, that's all in your control. And I'm at your beck and call. I don't tell anybody anything unless you tell me to. So it's going to stay confidential unless you change that. But there can be good reasons to change that. And one of them can be making sure that people know what the plan is. Just having that sense of understanding, this is what was supposed to happen, can be incredibly important to helping people accept the reality of what begins to occur after you pass. So if you say in your will you want X, Y, Z to happen, or like we've been discussing, you want so-and-so to be a candidate for taking the guardianship of your children, it might be helpful for people to know that. It's definitely helpful for the person that you nominated. I have seen movies where the scenario is thrown out there about a young woman who, is living free and life on the fly, and is suddenly dropped a set of children, and you kind of go, oh wow, that's crazy, and that makes for some really good movie fodder, but it's terrible real life. You would never want to do that to a person, so don't. Give them some idea of what's coming up and what they might be facing. It's kind of the godfather, godmother conversation in a lot of ways, or ratifying it. You may have already kind of had that conversation, but never actually put pen to paper, so to speak. Just naming somebody, generally speaking, as, godfather or godmother doesn't legally have the same kind of import. So, if that's what you've already discussed, this is the place where you would put that into effect. So take the time. I encourage you anyways to take the time to communicate with the folk that appropriately should hear it. And certainly children as well. There are a lot of hard conversations that parents don't want to have with their kids. I'm sure you're thinking of a couple right now, and we're not going to go there today. But this can also be one of them. Money, how it works, what you do with it, what's responsible, what's not. What they should expect in terms of inheritance. Like if you have actually said, I'm going to dole things out in slow doses, so to speak, give them a heads up so that they're not too upset. They kind of know that it's coming. You don't want them to think that there was something nefarious that occurred when in reality it was just good planning. So do be thoughtful about those considerations. Now, I know as a prior foster parent myself, there can be some questions of, well, I know it sounds like I don't have as much of an immediate connection as I thought I would. And so I'm kind of curious about, well, how does that work, and what process, if any, do I have to play in it? So I'll make note here real quickly to kind of some, this is law on who can participate in district court cases that are ongoing when you have a child who is coming to you in foster care. The benchmark generally is number 5 here, which is that any person with whom a juvenile has resided for 2 years or more does have the position to involve themselves in a petition for termination of parental right. Now, many times this is completely unnecessary, and there's no need, especially if you have volunteered yourself and you are part of the process. If you've had the child in your possession for 2 years or more, there's a very good chance that your social workers are working very closely with you, exactly like they should. And so you definitely don't want to encourage anybody to be litigious just for the fun of it, because it's not fun. But at the same time, certainly can't say that it's never called for. Otherwise, we would never have written it into our statutes. And so certainly if that's something that you're pondering about, is I would like a child that I have in my home to be more involved and to have more of an active, legal position with the child, be it guardianship or adoption. That's the initial benchmark. To be mindful of the fact that how long has the child been with you, and currently right now it's 2 years or more. So certainly I would encourage anybody who has more questions about that to probably reach out to an attorney to have a hard conversation about that and what your thought processes are. But that's about the extent as it relates to foster care in terms of where you might kind of push for it. But again, oftentimes this is going to be unnecessary because it's just you're already kind of moving in that direction with social services. So it'd be a pretty unusual scenario. The question comes up, at least, that I've heard over time, what happens if parents pass away mid-case? And so I'm going to take this in twofold here for a second, because we have legal parents, the ones that the child has been removed from, but then we also have the foster parents, the one that the child is placed with. So it's first important to remember that in this scenario, when you have a child that is currently involved in a legal matter such that they've been removed from the home, that the Department of Social Services is the one that has the legal custody. So technically speaking, the death of a biological parent that was the subject of the proceeding or of the foster parent doesn't have an immediate legal shift. What it does is begin to open questions about what needs to happen with that particular child in terms of guardianship or adoption potentially, or a change in placement. So I guess kind of walking through, a scenario where one of the foster parents passed away, that does not necessarily by law require a change in placement. And so that would certainly be a very hard conversation to have, to discuss, and to kind of work through. In theory, the child could stay right where they are if that's what the foster parent wanted, and it all kind of continued to make sense. I can imagine, though, that, similar to having a birth in a family can be a trigger for potential change. This is also, again, it's a factor. So, yeah, and so that's a thing to keep in mind. That again, it's not an automatic, but at least legally, anyways. But again, I would imagine that most social services would say probably need to make an adjustment here because that's a really big deal if you've lost a parent. Now, again, if we have a situation where the parents biological that don't have custody at the moment, we really would need to know, was that the last of two, or is it just one? Because if we have two parents that are still living and one of them passes, we still have the other parent that we have to work through in terms of resolution of the court proceeding. Whatever it is that caused the child to be removed, that particular parent still has, they have their parental rights. And so those have to be dealt with. So in one way, it kind of would be tantamount to one parent's rights being terminated. So it really wouldn't have too much of an actual effect on the current placement. At least I wouldn't think so. But if it was we had already maybe terminated one parental right, or that one had already passed away sometime, and then the other passed away, that would mean that we now have a situation like what we discussed before, where the child has no biological parents. We've got to find a placement. And presumably, because DSS is going to default to kinship placement, if the child is in foster care, that means we don't have that, or something that's going to work. And the guardianship petition that would follow, I would say, would have a fairly good shot at the current foster parents, if that's what they wanted, to be able to pick up in that situation. Or it would just escalate to the point where if the foster parents are saying, well, we're only here for the temporary, we're not here for the long term, that's somebody else's place, then it would just move into that phase, if you will, kind of like what you would see with a termination of parental rights. So this is a factor, and it's a multi-layered factor. But the key, or I guess the root that you can kind of grab hold on, is that DSS is the one with custody making decisions about placement. And so they're still going to have that role and that function, even though someone has passed away. And so for them, really, it becomes a decision-making process of, well, how does this affect, and discussing that with the court and getting proper approval for a change and going from there. Hypothetically, if the biological parents, even though the child had been removed, if they had done wills, and the last one to pass had actually stated some sort of a preference in that will, that would be a very strongly presumptive position that the court would take. So if you are in a position where you're having really good meetings with a biological parent, sometimes that can be the situation. And it seems like that everybody kind of knows where it's heading, so to speak. As unfortunate as that may be, the parent, if they are proactive, for whatever reason, they could theoretically do a will and say, just in case something happens to me, this foster parent placement is good. That would certainly help. It wouldn't hurt anything. That's a theoretical. I don't think that happens very often, but again, it could. But it does have weight, and so that's something to know. Probably not very practically helpful. And to that point, just to be really clear, if you are a foster parent and you have, let's say for a moment, only foster children in your home, you don't really have that nominating authority. So you could say it, you could write it into the will, but you don't really have that positioning to say, this is what I want to happen with the child after I pass. Because again, legal custody is in the hands of the Department of Social Services. And so if you as foster parents pass away, it's just a change in placement. There's not, again, going to be any kind of a reading of your will for the purpose of any of those child or children that may have been in your home at that particular time. If you have guardianship over a child, there is actually a process in which you can go ahead and set up a successor guardian for a minor. And so you can go through the process of declaring with the court, hey, if something happens to me, this is who I want to be the successor guardian. So it is actually a thing that you can do. And then obviously, as I've said before, with adopted children, you really need to do that because we're all looking at you. That is your child biologically, legally. And so your will is going to control that kind of a situation. So with that, I think I will pause here. I've got a couple of questions, and I'm going to try and clarify those. And so as a quick note while I'm doing that, if there are those of you who are holding on to questions and wanting to fire those off, this would be a great time to do that. The question is that, am I saying that most people who are guardians leave that child something in the will? So I guess to kind of break that a little bit down, if you are a actually appointed, nominated guardian for a child in your home, I don't know that I can say what most do. What I can say, though, is what they can do. So kind of think about your will this way. There are no boxes around what you can do with your will in terms of your own stuff. While the laws of intestate succession would say that normally your stuff goes to your spouse and or your biological children, or if you have no spouse, down to your biological children and grandchildren and great-grandchildren. Like it sets these things out, and that's what's normal. You're not restricted to that at all. You could say, I want everything to have to go to charity A. Oh, okay. And in which case, no living person receives a dime from you when you pass. Everything goes to charity A. Well, if you can do that, you can certainly also decide, well, I have essentially raised this particular child, be it through the legal formalities of a guardianship, or maybe the informality of simply, having a child in your home with the permission of the parent, which is not too terribly uncommon. Like again, the scenario of an aunt who raises her niece or nephew. Perhaps there could be reasons for the parents to travel a lot or something to that effect, or whatever the case is. You didn't adopt the child. You didn't even have to get guardianship. The child maybe never even went through any kind of a foster scenario or anything like that. They just, you raised them. And so if you raise them, you may want to write into your will, treat them like my kid. Parents who have, again, the blended family scenarios that I discussed, where you may have stepchildren that aren't legally going to inherit from you. You may say, treat them like my kids. And so I'm going to ask you to do that. So that's certainly within your right. And so I hope that clarifies that a little bit. That I don't know what most do, but it is something that you can do. And so if that's maybe something that bothered you about guardianship, was the idea that the child wouldn't inherit or something to that effect, you could fix that through a will, if that's, again, part of it. I think the question was asked about the statute reference. So 7B-1103, and that statute is in the context of termination of parental right. And so if you, that's where that one came from. So if you are a person who has continuous residence with a child for 2 or more years, then you are now qualified under that particular statute to involve yourself in that kind of a petition. And that may just be as simple as kind of like flagging the court. Yeah, I want to be involved. And I want to be considered if for some reason you felt like you weren't being considered. Seems like an odd situation, but I guess, again, it could occur. So I think I'm still showing a lot of live attendees, and I've got more time on the clock. So if you have more questions, I would encourage you to bring them on. And I guess can experiment with it maybe, but if there are any of our social workers that feel like there's something that I've said that needs to be corrected, please do that. And let's see here. Oh, somebody said there are questions in the Ask Question section. Ooh. Here we go. Thank you so much to Heidi for bringing that up to my attention. I totally missed it. That's bad on my part. All right. So if a parent has full custody of the children and passes away, can she have guardianship go to a spouse, domestic partner, or relative, or does the non-custodial parent get full custody? Okay, so this sounds like a little bit of a family law question, given the terminology of custody. So like if we're talking about 2 parents who are still alive, one has taken custody and the other does not have custody, but they probably have like visitation rights or something to that effect. And so I'm going to assume for the purpose of this question that parental rights have not been terminated. And so if parental rights have not been terminated and the parent who has custody passes away, the presumption in that particular circumstance is going to be that the other biological parent who still has their parental rights is going to be the one to take over from that particular time going forward. So that is definitely a very heavy question and a very heavy reality. that needs to be discussed and thought through. But I would still, even in that situation, advise somebody who's doing their own will to go ahead and make guardianship selections and to say, this is what I want to happen should a guardian be necessary, because a guardian wouldn't be necessary as long as we have a living parent. That's part of the calculus of what we're saying there. But still go ahead and select, because you don't know, as you know, as difficult as it sounds, like it's, you know, kind of a survivor issue, you know, winner take all sort of thing, whoever lives longest. And so if you happen to be the one to survive the other, you definitely still want to have this in place, right? However, if that is not the case, then there may be other things that you want to discuss doing to kind of help address that particular situation after the fact, because essentially it's going to be a continuation of what has probably been an ongoing custody issue. And so that's going to be in conjunction with family law attorneys and things of that sort. Okay. Let's say you have the hypothetical that's given here. You have guardianship over a child, and then you pass. What happens to the child at that time? Who appoints the next guardian? So in this particular situation, this is where it's going to get a little bit muddy, because we are going to have a question about which version of the guardianship that we're talking about. Because there is, again, that guardianship that kicks in that's with the clerk of superior court, where you have both parents who are gone or parents who have had their rights actually terminated. And if that is the case, then that particular guardian would presumably want to register a successor guardian with the court and say, hey, this is who should take over at the time that I pass. That's really the proper way to do that. You could, in theory, just say it in your will just for the sake of there being something out there, but legally, you would really want to have the actual appointment of a successor guardian made sometime before you pass away. But if you are made a guardian as a part of a foster care situation and parental rights have not been terminated, that is a situation where the Department of Social Services is all likelihood going to come back into play, because the parental rights are still there, but there was something that was kind of keeping the parents from being able to exercise custody over the child. We're going to be coming right back into the court scenario in all likelihood. So yeah, you definitely want to have like some good conversation about your particular guardianship scenario and under what authority that you've been named as a guardian. So again, it's a good thing to sit down and really like focus in carefully, like what is that particular situation that I'm in, because the guardianship term gets used in at least two different contexts, if not more than that, within our statutory breakdown. So, yep. Well, I'm at the hour mark, and I know that it's important for holding people's attention to stick to times as they are. It looks like people who have wanted to ask questions have done so. However, I will note that for all of you who have participated here today, if this was helpful to you at all, when I sign off, the recording is made public at that time, and the same link that you use to register is the same link that you can use to, you know, send, or if you want to watch again or share it with somebody else if you found that to be good. You know, otherwise, then you can reach out to myself, the law firm. Apparently, I have a promo thing here, so this is specific for y'all. So definitely let us know if that's something that you're looking to get done. Certainly always encourage folks to reach out to Department of Social Services, particular Durham, that hosted this today, or at least kind of helped out with the marketing and things of that sort. And so, I certainly always found folks to be very helpful and wanting to, provide information. So encourage you to utilize that. So with that, I will wish everybody a wonderful evening, and I certainly hope I see a lot of y'all that I know, and I hope to bump into you soon. But take care.